Welcome to everybody joining. We'll begin the webinar in 1 minute. Folks are rolling in. I see we have 27 attendees so far.
That's good.
Gonna give it 1 more minute while everybody continues to join. Welcome from all parts of the world. Feel free to share where you're coming in from on the chat function, and welcome to the ADR World Tour. Welcome, Sarah. Welcome, Edward. Kenya's in the house. And Botswana, that's great. And Zimbabwe, that's wonderful. Welcome, everybody. Well, I believe the local time is 2:01, and welcome to Ibrahim as well. My name is Brian Brannon, and I sit on the board of the Chartered Institute of Arbitrators North America branch and its Young Members Group Steering Committee. On behalf of the Chartered Institute of Arbitrators Young Members Group Steering Committee, it's my pleasure to welcome you to the ADR World Tour, Arbitration and Mediation as a Global Force for Good. The Chartered Institute of Arbitrators Young Members Group presents a series of international webinars which highlight the unique importance and efficiencies ADR plays in allowing the world's economy to remain operative and functional, even during times of great economic uncertainty. Perhaps no greater time of economic uncertainty exists than today. 11 regional webinars will take place across the world, which focus on ADR and access to justice, ADR as an efficient alternative to traditional litigation, and the ADR as a means to strengthen the rule of law. We've so far completed 3 weeks of the ADR World Tour. The first week completed with 4 series in Asia. We then moved to the Caribbean and Central America. Last week we were in South America, and this week we are proud to be in Africa. This Chartered Institute of Arbitrators ADR World Tour is managed by a group of 18 central organizing group members, and today it is my pleasure to be joined by one of those, a local to Dar es Salaam, Tanzania, Madeline Kimmy. Madeline will moderate today's panel, and we are pleased for her contributions and to have all panelists involved. Madeline?
Thank you, Brian. Thank you so much for introducing all our attendees to this wonderful, wonderful world tour that touches on ADR, Alternative Dispute Resolution. And today we'll be focusing on East Africa. We are embarking on an African tour the whole week. And today's session is an East African panel that will touch on what we have set up to be Africanization and what the future holds. ADR in Africa, Africanization and what the future holds. And this concept and theme comes about from us being able to witness certain reforms, several reforms within different states within the African continent, and which have resulted to the evolution of Africanization, of alternative dispute resolution mechanisms, and of course, not forgetting the impact COVID-19 has had in terms of affording parties the disputants in any occasion access to ADR in Africa. And so our panel today, we have 4 panelists. Mutanzi Matuvelo. Mutanzi Matuvelo is from Tanzania. He is working in iResolve. He's an associate director at iResolve. He's an advocate of the High Court of Tanzania. He holds a bachelor degrees in law and honors from the University of Dar es Salaam. He's got a post-diploma in legal practice from the Law School of Tanzania, and embarks on a master's degree in commercial law and was awarded a certificate in mediation and arbitration by the International Law Institute and International Academy of Trial Lawyers in 2019. Mutanzi will be touching on grooming young African arbitrators, the situation here in Tanzania. We will then move on and go straight ahead and hear from Leila Ahmed, who is based in Kenya, Nairobi. She's an advocate and an associate in the Dispute Resolution Department at OK Law LLP, specializing in commercial litigation, employment and labor disputes, civil and constitutional and human rights matters. She is a commissioner of oath, a certified mediator, and has been provisional accredited by the Mediation Accreditation Committee of the Judiciary of Kenya. This is Leila. She's an arbitrator, a fellow of the Chartered Institute of Arbitrators, and her full profile is also contained on the website of the Chartered Institute of Arbitrators, where you found the link to register. Now, she will be touching on Africa and ADR, the evolving landscape in Kenya. We look forward to hearing from her. We will then hear from Asmahane Saad. She is based in Uganda. She's an advocate, a commercial legal advisor, and an alternative dispute resolution practitioner by profession. She is a partner at KTA Advocates and heads the corporate and commercial practice group with the niche in energy, including oil and gas, infrastructure, and natural resources. She's a committee member on the first ever appointed investment advisory committee that advises the Minister of Finance, Planning and Economic Development on the Petroleum Revenue Investment Reserve Fund in Uganda. And she will be speaking on status of ADR in Uganda. What does the future look like? Please do follow on the link to read her full profile, a well-accomplished profile. We'll then finish the session with Dr. Fidele Masengo. He's a fellow of the Chartered Institute of Arbitrators. He is also the former registrar at the Kigali International Arbitration Center. He is a PhD holder from the University of Antwerp in Belgium, and a master's in law, economic law, from the University of Louvain in Belgium. He is a legal consultant, an arbitrator, a certified mediator as well. Since 2015 up to 2020, as I had said before, he was the Secretary General of CIAC. Please do follow on the link to read his full profile. He will be speaking on ADR in the time of COVID, implementation of current legal and policy frameworks in Rwanda. We really are having a panel that will touch on each of their topics. And just before we begin, this particular session, as has been the theme around arbitration and mediation as a global force for good, I would like us all to note the definitions that one could use with regards to defining arbitration. For example, Lord Justice Raymond defined an arbitrator as a private extraordinary judge between party and party, chosen by their mutual consent to determine controversies between them, and arbitrators are so called because they have arbitrary power. For if they observe the submission and keep within their due bonds, their sentences are definite, from which there lies no appeal. I think that gives us a practical definition of what arbitration is. And then we move on to mediation, which are the two key ADR mechanisms that will be focused on during our webinar. Is that I go to the model law under Article 1, subsection 3, which provides a very good definition. Mediation being a process, whether referred to by the expression mediation or conciliation, or an expression of similar import, whereby parties request a third person or persons to assist them in their attempt to reach an amicable settlement of their dispute arising out of or relating to a contractual or legal relationship. The mediator does not have authority to impose upon the parties a solution to their disputes. These are the two ADR mechanisms that this tour focuses on, and on Africa and East Africa, we'll be focusing on these two mechanisms. So let's kick off with Tanzania. Mutanzi, welcome and take the floor.
Thank you, Madeline, for the introduction. Good afternoon and greetings to everyone else according to their time zones. I can't specify each time zone, but greetings to all of you. It is a pleasure to be a part of this global tour. It's an honor, not only a pleasure, to be amidst of the likes of Leila, Asmayan, Dr. Masengo and Madeline here in Tanzania. Let us go straight in. I understand I have 15 minutes, so I'll do my very best to make sure I use my time effectively to cover all that I have and entice you to come visit Tanzania. My topic today is on grooming young African arbitrators. We'll be talking about the situation in Tanzania. I am a young practitioner myself, so this is me speaking what I feel is going on and what I have seen to be true thus far. It is rather it is more of a personal experience than otherwise. Let me start by saying Tanzania has, as of January 2021 this year, brought into force its new Arbitration Act, the Arbitration Act of 2020. The enactment ushers in a long overdue piece of legislation which does away with our old Arbitration Act, that of enacted first in 1931, and it was based on the 1889 English Arbitration Act. The new act brings Tanzania closer to the global reality of arbitration as not merely alternative means, but rather an appropriate means of dispute resolution, subject to the matter at issue. In light of the new act, I endeavor to discuss the issue of grooming young African arbitrators as far as Tanzania is concerned. For a long time, the law did not provide what qualifications one ought to hold so as to be accredited as an arbitrator. This is mostly because the old law did not provide for accreditation. And more to that is that accreditation was never a big of an issue, as no authority or organ was ever tasked with arbitration, with accrediting arbitrators, mediators, or reconciliators for that matter. Private arbitration and mediation in Tanzania has for a long time been done through private arbitrators self-accredited owing to their legal accomplishments, for example, retired judges or very senior advocates. And other accreditation mechanisms has been through the Chartered Institute of Arbitrators, UK, or its chapters around the globe, the Tanzania Institute of Arbitrators, or the National Construction Council. But the new act under Section 77, subsection 1, introduces another accrediting authority and another authority under which arbitration can be conducted, the Tanzania Arbitration Center. This act also amends our Civil Procedure Code by adding Section 64C, which creates under the Ministry of Legal Affairs the person known as a registrar, responsible with registering and accrediting negotiators, mediators, and arbitrators. To give effect to this accreditation mechanism and arbitration as a whole, the reconciliation, negotiation, mediation, and arbitration practitioners accreditation regulations were enacted this year, January this year, 2021, which sets out the criteria to be met by an aspiring arbitrator. And more specific or to the point is Regulation 6, Subregulation 1A through F of the regulations, which provide the requisite criteria. These criteria include persons who have the qualifications to hold the office of a judge of the High Court, can be registered, can apply to be registered as arbitrators. Persons with training from dispute resolution institutes, recognized dispute resolution institutes, can be registered as arbitrators. Persons who have sat in tribunals, in dispute settlement tribunals, international or national, for the past 5 years or more, can be registered, accredited as arbitrators. And other people, not necessarily lawyers, just if they have 5 years of experience in their respective fields, they can apply and be accredited arbitrators. Reading these criteria, it is obvious that arbitration practice is not reserved for those persons learned in the law, but would accept individuals from different trades, subject to, as I have said, the number of years they have in their respective practice, and the minimum of which is 5, or dispute resolution qualifications from recognized institutions. Now, the gist of the discussion is how can the ADR community groom young African arbitrators to become reputable, eminent arbitrators, both in their local spheres and in the international realm as well. In as much as academic qualifications are of inextricable importance, the making of a good arbitrator requires more than that, more than academic qualifications. It requires, in my opinion, craftsmanship only afforded by practice. To groom a breed of young African arbitrators capable of working in the international stage, mentorship is key. Mentorship is of great importance. Not only should a person have a degree, not in my opinion, not only should a person be registered with a certain practice, but mentorship as to how arbitration is done both in the national and international level is key. Through mentorship, new, young arbitrators get to see seasoned arbitrators at work, giving them an opportunity to see in practice what they know from their academics, and an opportunity to carve out a practice style most preferable to them. Though the importance of mentorship cannot be overstated or cannot be overemphasized, I beg to argue that its supply is rather wanting. To understand this, I will explore one encompassing factor which plagues arbitration and arbitration mentorship in Tanzania. This one factor, to me, is the culture. By culture, I do not mean the general culture, but rather and exclusively the perceptions and approach of practitioners and the general public towards ADR in general, arbitration specifically, vis-a-vis litigation. In Tanzania, arbitration forms one means of dispute resolution, but it is by no means the default or the go-to option compared to arbitration. Compared to litigation, arbitration is not as commonplace. This in part stems from the training lawyers in Tanzania go through in universities, where most, if not all, are groomed for practice in an adversarial manner. This robs most of the understanding of the need for a win-win outcome and the efficacy of arbitration as an appropriate means of dispute resolution. In my personal experience, had it not been for me joining the Chartered Institute of Arbitrators as a student, I might have not been able to appreciate the versatility of arbitration and ADR as a general means of dispute resolution. And which has brought me to argue, does ADR stand for alternative dispute resolution or appropriate dispute resolution? But that, I'll leave that discussion for another tour. Such training, as I have earlier captured, where lawyers are trained to go and practice in an adversarial manner, diminishes in the eyes of many the value of arbitration. To add to that, the general adversarial legal system goes further to instill to the general masses a misconception that litigation is the only way to get justice. Mixed up in this misconception is the desire to litigate so as to show the other person who is boss. And in formal settings, I would say ego comes to play and everything is a mess thereafter. You fail to see what is really in your best interest, even if it's right in front of you, just because you have the desire to show the other person who is right and who is boss. In my opinion, this is a grave misconception, and it's deeply engraved in our culture and the legal system, the litigation legal system. Thank you. With the foregoing, it does not help that the greater public is ignorant of arbitration and ADR at large. This is general ignorance. This in turn decreases the number of matters referred to arbitration and the parties' propensity of allowing mentorees to sit in during arbitration sessions, which form a crucial part of the mentorship programs. With this discussion, I have a call out as I wind up. Arbitration institutes, in my opinion, would be best served in their attempts of having good arbitrators with investing in educating practitioners and the general public on the efficacy of arbitration and the importance of mentorship for sustenance. A synchronized and deliberate measure across the continent to groom young African arbitrators is a sure way through which a breed of young African arbitrators can rise to the occasion set by the international stage. This should serve as a call for a joint work between, let's say, the Tanzania Institute of Arbitrators and other institutes across the region, across the continent, to groom our very own through a change of culture and the disposition to opt for ADR rather than litigation. Madam Madeline? Thank you.
Thank you, Mutanzi, for that well-presented paper on grooming the young arbitration practitioner. And he makes a call at the end of his presentation for there to be joint efforts in grooming these young practitioners, not only the practitioners, he points out, but also the general public, the users, the end user. It's a very important question. I'll come back to you, Mutanzi. We are now driving through Kenya and meeting Leila Ahmed, who would be presenting her paper at this moment. Karibu sana, Leila.
Asante sana, Madeline. Ben, for you who doesn't know Kiswahili, that means thank you very much. This being East African, hamjamboni, good afternoon. I had a presentation. I don't know whether I'm able to share that. Let me try to share that. Okay. Is that visible now?
Yes, it is, Leila.
Let me just put on slideshow. All right, thank you very much. As Madeline had said, I'll be concentrating on the evolving landscape in Kenya. Contrary to what Madeline said, the fact that we are concentrating only on arbitration and mediation, I'd like to take just a slight shift and introduce traditional justice systems. So in Kenya, I'll be discussing about the legal and institutional reforms that have enabled transformation within the ADR sphere in Kenya. One of the things that is important to note in Kenya is that majority of the communities have already have some sort of justice systems in resolving their disputes. When you look at one of the key principles to guide the administration of justice, and the exercise of judicial authority in Kenya is the requirement to ensure that we embroider alternative forms of dispute resolution. Article 159 of our Constitution mandates the judiciary to promote ADR in the administration of justice. And it does give forms of ADR in the Constitution. There's reconciliation, there's mediation, arbitration, and traditional dispute resolution mechanisms. These modes of dispute resolution shall only be used as long as they do not contravene the Bill of Rights, they are not repugnant to justice and morality, and it is not inconsistent with the Constitution or any other written law. Thus, under the Kenyan Constitution, it is recognized the value of the formal justice system as well as the traditional justice system. For this reason, for this important reason, I'd just like us to slightly just discuss a bit on the traditional justice system. As I've already mentioned earlier, majority of the Kenyan communities have their own justice systems, which they have been using to resolve their own disputes over the of time, even at the time of the colonial, before the colonials came in. Our former Chief Justice, Dr. Willie Mutunga, on 10th March 2016, gazetted a task force on informal justice systems. The mandate was to develop a policy to mainstream into the formal system traditional informal justice systems used to access justice in Kenya. Now, in 2017, there was a survey that was done between the Judiciary of Kenya, Hill, and the World Bank. There were about 6,000 Kenyans who were interviewed for this survey. And they found that the majority of the Kenyans will prefer to take their disputes to the chiefs, or some of them prefer to take it to the churches and the mosques as opposed to the formal system. This shows that from these statistics, you see that 19% of the respondents prefer to take their disputes to the chief for resolution. This is the informal processes. 15% preferred the family. And clearly you can see that lawyers are not needed in the process because only 7% thought of, including the lawyers. Now, this process, what the task force did was between the task force was gazetted in 2016, and it took them 4 years to come up with a policy. This is understandable because one, Kenya is a vast country and they had to transverse the country to understand different communities and their mode of dispute resolutions. Take, for example, the northern part of Kenya. They use a system called Maslaha. Maslaha is a system where now the elders come in to resolve the dispute. For example, if the neighbor has one way or the another, maybe there was a dispute, the elders will come together, try to resolve it, and as a means of resolving the dispute, to find once they hear the parties, the other party might be asked to maybe give a livestock or pay in form of money. Now, I like to read this important, what the immediate retired CJ, it seems like our CJs are all retiring, Justice Maraga indicated when he was during the AGC policy last year in August. He said Kenyan communities have for generations developed their own justice systems that have held and continue to hold societies together. While justice dispensed by the courts has occupied the center stage in the administration of justice, the reality is that the vast majority of disputes, as much as 90% among Kenyans, are resolved through systems that are outside the formal court system. Alternative justice systems as exposed in this policy are community-centered and reflect the lived realities of the people, and therefore eminently more accessible to most people. Why did I bring this topic up? Because we are talking about access to justice, resolving disputes. 90% of Kenyans resolve their disputes through the within the community. So it's important to see how we can bring this form of dispute resolution and try to integrate it with the formal dispute resolution. Having gone to different communities, the task force have a few recommendations in the policy, and they recommended 3 models of the practice to be adopted in Kenya. The first one was the autonomous institution. This means the process is entirely run by the community. The community will pick third parties who will be selected to resolve the dispute in accordance with the laws, rules, practice that govern that particular community. The state is in no way involved in the autonomous institution. This is purely run by the community. Their second model was the third-party annexed institution. This meant that it could be run by the state-sanctioned institutions such as the police, probation officers, child welfare officers. Then the third proposed one was the court annexed institutions. Definitely this was outside the court, although under its guidance and partial involvement. Why partial involvement? Because it will mean that it will be probably the police and the courts that will refer the dispute to for resolution under the said system. Now, there are people who have questioned this traditional justice system resolution of dispute. They're saying, I mean, someone has killed. Why will some communities sit down and try to just, in order to just appease the family, maybe give amount of their fine, some cash, or pay some cattle or something. So they believe this is not a form of justice. So they'll say the people who argue that they still argue under the repugnancy clause that it contravenes any other written law, which I do not believe, because as the policy says, the repugnancy clause should not be seen as a stumbling block, nor be allowed to continue as a supervising doctrine for customary law. But again, the question is, whose morality are we talking about? Who is going to determine what morality is? If a certain community has decided, this is our morality, this is our system, this is how we want to resolve our dispute, who are we to say that is not your morality? What applicable standards are we going to use? What is justice anyway? What is justice to me may not be justice to you. Those are the questions I like to leave with you as what you've discussed. The next issue, sorry if I'm running through this, I think I only have 10 minutes. We have the court annexed mediation. This is a mediation process.
You have 7 more minutes.
I have?
7 more minutes.
Thank you, Madeline. The court annexed mediation is a process conducted under the umbrella of the court. The High Court Annex Mediation was launched in 2016. It was initially a pilot project which started in the High Court Commercial Division in Nairobi. The project is being implemented in phases in various courts within the country. And since 2016 to date, there are very many courts within the country that have started the project. What happens once, let's say a party has filed their matter in court, the cases are screened by the deputy registrars to see whether it should be mediated upon. The court accredited mediators are then appointed within 7 days by the court. The mediation processes ideally should be concluded within 60 days, which period can be extended, but the mediator is supposed to apply to the court for that extension and by the agreement of the parties. Here, parties can select their own mediators, but the same will not be under court annex mediation. For it to be court annex mediation, it means that it's the court that is selecting the mediators. However, if it's outside that, the mediation settlement can be registered by the court. There's also a mediation judge who handles interim applications and issues appropriate reliefs if necessary. With COVID, of course, Kenya had to step, and now we have the court annex mediation, virtual dispute resolution. Parties must be willing to participate in virtual mediation. The court may refer pending or new matters to virtual mediation. Even parties may request the court to refer their matters to mediation, to virtual mediation. Just like any other mediation, e-mediation should be private, and only the mediators and the parties are allowed to be in the session. I like to just give you statistics of mediation cases in the commercial and tax division since inception. The total number of matters referred to mediation have been 463. About 338 have been concluded. You'll find that the value of matters referred to mediation is 24,284,884,270. Clearly, you can see without the value why the court annex mediation is really important. When we talk of non-compliance, those are for one way or reason, either of the parties have not complied. Maybe they've not filed their case summaries. Maybe they've not been attending the mediation sessions. Terminated cases are 51. It means probably one, the mediation session never took off, or once the case was screened for mediation, the court then realizes this is not a matter that should have gone to mediation in the first place. Now we move to what Madeline said should be our main topic, arbitration. Kenya has positioned itself as a leading business hub in East Africa, or probably it's the leading. Madeline will kill me. As I've said previously, Kenya and Tanzania, we share a love-hate relationship, but Kenya has positioned itself as a leading business hub in East Africa. In the Ease of Doing Business 2020, this Ease of Doing Business compares 190 economies. Kenya was ranked at position 89 in the enforcing of contracts category. The enforcing contracts indicator measures the time and cost for resolving a commercial dispute through a local first instance court. They gave an example of a claim of 536,000 Kenyan shillings in the lower courts. They estimated that this takes about 465 days to conclude in Kenya, compared to any other sub-Saharan African country, which takes 654. The same claim takes about 120 days in a place like Singapore. Hence why then arbitration becomes attractive, because when you look at courts, such a low value matter, which is less than 500,000, is taking about 4 months, 5 months, 6 months. Kenyan Arbitration Act applies to both domestic and international arbitration, unless partly rightly exclude the application of the Act to their dispute. The Act is modeled unilateral model law in arbitration. There is reduced court interference in the arbitration processes, as clearly indicated in Section 10 of the Act. Section 12, 14, 15, and 16 prescribe limited instances of court intervention in relation to the appointment, challenge, impossibility to act, and withdrawal of an arbitrator through an application to the High Court. The Arbitration Act covers both domestic and international arbitrations. It does not expressly prohibit certain disputes from being arbitrated, though there's a general consensus that criminal matters cannot be arbitrated. The Limitation of Action Act does not expressly limit number of years an arbitration claim can be brought, although an action founded on contract and tort can be brought within 6 years. An action for the recognition and enforcement of awards cannot be brought after 6 years have elapsed from the date the cause of action accrued. What is domestic arbitration? If the agreement provides expressly or by implication for arbitration to be in Kenya, or at the time when the proceedings commence, the arbitration is entered into the parties, both parties are nationals of Kenya or habitually reside in Kenya. It is also considered a domestic arbitration where the arbitration is between body corporate, where the parties are incorporated in Kenya or their central management and control are exercised in Kenya. The Act considers it to be an international arbitration if the parties to an arbitration agreement have their places of business in different states at the time of the inclusion of the agreement. Where a substantial part of the obligation in the underlying contract are situated in a place outside the state in which the parties have their place of business, the same then is considered as an international arbitration. Making Kenya a preferred seat of arbitration, the courts are pro-arbitration and minimize the intervention of the court in the arbitral proceeding. For example, this case that was decided last year, Pit Stop Technologies, the applicant had recommended appointment of one of the arbitrators. The respondent never responded. So the applicant moved to court to have the court appoint the arbitration, but the court refused. It's noted that the default by one party to appoint an arbitrator in abiding by the principle of party autonomy, the process remains in the party's hands and that the court shall not intervene prior to appointment of the arbitrator. So the applicant was told, go ahead and appoint, and that the court can only come in once an arbitrator has been appointed. Although in Kenya, there are no specialized courts dealing with arbitration matters, judges in the commercial division are regularly trained about arbitration. We have the Nairobi Center for International Arbitration Act, which establishes the Nairobi Center for International Arbitration, whose function includes to promote, facilitate, and encourage the conduct of international commercial arbitration. The government of Kenya has designated NCI as the default arbitral center for any government in government of Kenya contracts to resolve any dispute. This is to promote Kenya as a venue, as the seat of arbitration. Kenya has led in trainings, it being the only center in Eastern Africa. It has undertaken trainings in Malawi, Dar es Salaam, Uganda. The Chartered Institute of Arbitrators Kenya branch trained judges for the Eastern courts, both the East African Court of Justice and COMESA. Quality of Kenyan arbitrators, I do confirm we are top up there. They're well-trained, qualified, and seasoned arbitrators. The African Arbitration Academy just released its power list arbitrators. We have 4 Kenyans who appeared in that list. CIArb, African trustee, Dr. Kariko Amigwe, has really steered the leadership in growing domestic arbitration. I was discussing with someone who actually confirmed that in his website alone, he has over 96 articles. So we have well-qualified arbitrators within Kenya. Appointment of young arbitrators. The center has a rota. Any person who has undertaken the training, who has done his mentorship, is eligible for appointment. And every time the institute looks at the rota and looks at, has Leila been appointed this year? When was the last time Leila has appointed? In Madeline, 1 more minute. I think the right of appeal is really crucial for us to have a discussion on. Let me just discuss on the right of appeal. This has been under Section 39 of the Act. It expressly provides for the right of an appeal to the Court of Appeal from the decision of the High Court, arising from either an application or an appeal on a question of law. Over the last couple of years, there has been that debate whether there's a right of appeal from the High Court to the Court of Appeal. And there have been conflicting decisions from the Court of Appeal, some saying, yes, there's a right of appeal, and some saying there's no right of appeal. Until 2019, we had the new 2 aggravate case. Well, since there was no consensus by the Court of Appeal on how Section 35 of the Act should be interpreted, the matter was taken to the Supreme Court, which is the apex court of the land, where it was called on upon to bring an end to the debate. The Supreme Court appreciated that Section 35 of the Act does not expressly indicate whether the decision of the High Court mandate thereunder is final. After considering the interpretation made by other courts, as a result, the Court of Appeal ought to have residual jurisdiction to inquire into such unfairness, because the Supreme Court held the view that it should, if one is aggrieved by the decision of the High Court, then that should not remain. It held the view that there should be the right of appeal to the Court of Appeal. However, the circumstance in which one needs to appeal should be limited. That has been the main development in Kenya, where there's now a right to appeal to the Court of Appeal. I think, Madeline, because of my time, I'll stop there.
Thank you so much for that mastered presentation. You have masterfully presented your paper and really painted the picture such as of that evolving landscape in Kenya, not only touching on the key mechanisms that we are focusing on, but also introducing the traditional aspects of our cultures that are embedded in the African continent. So thank you so much. Just so that we don't buy a lot of time, let's introduce and welcome Asmahane Saad, who would be presenting on the status of ADR in Uganda and what does the future look like. That is what she'll be presenting on. You're most welcome, Ms. Saad.
Thank you, Madeline. And thank you, Leila, and my colleague from Tanzania. It's such an honor to be here. I think Leila and my previous colleague from Tanzania, sorry, I missed the name, have really touched on some of the similar aspects of ADR. As a region, as a bloc in East Africa, we have a lot of similarities, especially us who are Anglophone. And we have a lot of similarities in the way even our judicial systems operate. But nevertheless, I will just quickly touch on the status of ADR practice in Uganda. And of course, to be able to understand our landscape as well, I will quickly just run through our history and how we have, as a country, driven the practice of ADR. So for starters, ADR or alternative dispute resolution is something that emanates right from our constitution. It is provided for and as a form of settlement for civil disputes. And arising from that, that was in 1995 when our new constitution came into place. We saw laws being developed specifically to support that component of our constitution. The first law was the Judicature Act, which clearly provided that alternative dispute resolutions and mechanisms, especially for arbitration and conciliation, were to be adopted in the civil court processes. And following that, the Civil Procedure Act then came to enforce this, and specific rules or orders were made to promote arbitration and mediation specifically. So, and about actually our first law on arbitration was in 1964. And this was way back even before our constitution, but alternative dispute resolution was recognized then. And so our first law for arbitration was enacted in 1964. This was the Arbitration Act, or CAP 55. And subsequently, after commencement of our constitution and Uganda being part of UNICITRO, in 2000, a new law was put in place to amend the 1964 Act. And this is now referred to as the Arbitration and Conciliation Act. And what this law did was to bring in a component of conciliation into our ADR practice. So conciliation was provided for in this law. And I noticed that we haven't really, I think Leila hinted a bit on conciliation, but this is something that the law provided for mechanisms in which arbitration as well as conciliation would be supported by our judicial system. Later on, there was an amendment that was made to this act, and this was in 2008. And the amendment calls for government to come up with a support mechanism and institution, which is called the Center for Arbitration and Dispute Resolution. Now, this center was supposed to manage ADR mechanisms that would be arbitration, conciliation, and mediation. So the center came into force in about 2008 or 9. And from then on, all matters that needed support in terms of ADR, whether it was private or through court processes, were driven by the Center for Arbitration and Dispute Resolution, which we normally refer to as CIArb. And then as we evolved through this mechanism, we saw that in Uganda, more specifically, the need for promoting also mediation as a practice within court had to be adopted. And this really came from the background that a lot of jurisdictions, especially picking up from the international jurisdiction, from the practices that were being adopted by UNICITRO, being promoted, and how mediation was being used as a quick mechanism to kind of get to act as a doorkeeper to promote ADR and kind of salvage time for parties that would want to go for litigation. This was something that was really welcomed, and we had support from the European Union and our justice, law and order sector. And there was a program that was run in 2003, and mediation was first piloted at the Commercial Court of Uganda. And through this pilot project, a new rule was introduced under the civil practice, which was the Commercial Court Division Mediation Pilot Project rules. And basically this rule was to provide for a procedure in which mediation, court annexed mediation, would be introduced. And also these rules were supported by the Center for Arbitration and Dispute Resolution, CIArb, and they formed kind of a mechanism where CIArb would come into to support commercial disputes and take on the role of the mediators and try to promote use of court annexed mediation for settlement, especially for commercial matters. This project was quite a success, but unfortunately, due to funding issues, it had to close in 2007. However, the practices had been adopted, and the success rate was recorded to be at about 26% of resolution of matters at mediation. So we actually saw many countries as well come to benchmark just from this best practice of using court annexed mediation. We had countries like Rwanda, Tanzania, Malawi, Zambia, Nigeria, that was about in, even Kenya in 2020 come and just engage and see how they could also pick up this practice of court annexed mediation. However, with the success of this, however, it promoted the use of mediation. And what was left was to just formally introduce it now out of the pilot into a court process. And that was when the Judicature Mediation Rules of 2013 were introduced. And basically, these rules came to support court annexed mediation, and it expanded the scope from just commercial justice into all other scopes of civil justice. So we saw court annexed mediation being adopted by the civil court, the land division, the family division, and it became a rule of practice. Quickly, I'll just run into some of the silent features of these rules that made it really work from 2013, and they're still applicable to date. So the new rules, first of all, would apply to the High Court and all courts subordinate, which mean the magistrates courts, the grade 3, grade 2 to grade 1, they were all required to implement court annexed mediation for all civil matters before they could go for litigation. The rules, the new rules also would apply to all civil actions, like I said, and then it became mandatory for all civil matters to be mediated and no matter would have quorum before a judge if there was no mediation report. So we saw also this pulling up the statistics and a bit of understanding on how mediation would work. And then also in terms of who would be the mediator, the rules provided for a judge, a magistrate, or a court accredited mediator who is appointed by court to mediate. The rules also allowed for children to participate in their own rights in cases of children, and this is mainly in the family division. The rules also made it mandatory that costs of participating in mediation would be borne by the parties unless agreed by parties otherwise. The rules also came up with guidelines in how mediations would be conducted and also conduct of the mediators in general. The rules also provided for an monitoring and evaluation committee, which would be chaired by the principal judge and members of the High Court Division, the Solicitor General or his representative, the Chief Registrar, the President of the Uganda Law Society, the Executive Director of CIArb, all form this committee, which would then assess and establish whether or not there would be need for any changes in these rules. We've seen quite a number of success come out of court annexed mediation, and that has really made our civil court processes really adopt the system of ADR through court annexed mediation. In terms of arbitration, like I initially introduced our arbitration ecosystem, like I said, we have an institution that was appointed by government, that is CIArb. However, due to funding challenges, we found that CIArb was not actually performing like as fast as most of the arbitration institutions in the region were. For example, the Nairobi Arbitration Institute that Leila talked about. Rwanda had a very robust arbitration center. CIArb was really not living up to it, and really it was because of resources. And so in about 2018, an independent private institution was set up, and this is, it's called ICAMEC. ICAMEC stands for the International Center for Arbitration and Mediation in Kampala. It was started as an independent non-for-profit organization, and its major objective was to promote and advance ADR in Uganda and across East Africa. And ICAMEC was really driven by the private sector, and this came through mainly the banking sector, professional bodies that were really getting frustrated by the delays in court, and yet it was a well-stated fact of law that, you know, we are a country that had long time ago embraced ADR. So with that, when ICAMEC came into the picture, we saw a sort of awareness and a spotlight being highlighted on specifically arbitration and private mediation. Like I've given the background, because mediation was adopted in the court process, a lot of people ended up associating mediation with court process. So we found that this kind of channeled private mediation out of the system, and it's seemingly unheard of now for private parties to try and mediate privately. So just a snapshot on our status. So that is where we are now in Uganda in terms of our ADR practice. Some of the challenges that we are facing right now, like I said, the lack of awareness. Generally, arbitration, mediation, conciliation as ADR tools that have really been promoted through our laws have not been promoted as much as we want. And this really comes from a lack of awareness. And then also recently in 2020, the civil procedure rules were amended, and we saw this amendment affecting court annexed mediation, and summons for direction were issued whereby court parties would actually determine how their case process would be run. And so right now parties are driven by the legal professions. I'm an advocate myself, but we see that more and more cases coming out now, people are trying to avoid court-annexed mediation. Again, just to give you statistics, our backlog in the commercial court specifically, right now, as of August 2020, we had a backlog of cases worth 4.1 trillion Uganda shillings, and that's about 11 million United States dollars, which is such a huge amount of cases that are in backlog. We have over 5,500 cases in terms of number of cases that have not yet been resolved for over 5 years in the commercial court. Then, of course, like I said, interest by the legal practitioners. We are trying to promote and see that young legal practitioners or just professionals, get interested with ADR and start a force or a sort of movement that we can then see even this being picked up by the users of ADR to promote ADR practice. So some of the opportunities, if I can conclude with the opportunities, I think for Uganda, our landscape is looking quite promising. And this, I would say, is really driven by the fact that we've become a very big investment destination. We have a lot of investment coming in, foreign direct investment, and with that comes best practices in terms of dispute resolution. This is investments like in oil and gas, our infrastructure sector, and energy. We have a famous arbitration matter that was promoted by Tullow Oil. This was a dispute between Tullow Oil and the Uganda Revenue Authority. This matter took about 2 years, and it was settled in the London Institute of Arbitration. So they kind of set a pace and put a lot of highlight on, the efficacies of arbitration in terms of our investors and investment portfolio. Of course, with the setting up of ICAMEC, like I said, which is a private-driven institution, we want to see Uganda being promoted as a destination seat for arbitration, so we can have more people come in and more people promote, the use of Uganda as a seat for arbitration. Our electronic laws have supported ADR, which has kind of promoted it as well. We see now the promotion of ODR, which is online dispute resolution, which is clearly provided for in the laws of to govern the e-commerce sector. And with that, we are seeing that different users, whether it's usage on policies of this, whether it's a fintech or it's an e-commerce company, start to understand mediation or ADR and wanting to know more about it. So technology, and also as a result of COVID, has really promoted online dispute resolution. So to end, I will just say that, like I said, our future is quite promising, and I think with more promotions and more awareness, I think Uganda will soon be a very, very a suitable or a more sought out country for, or a seat for arbitration and ADR. So Madeline, back to you. Thank you.
Thank you, Mahane, Ms. Saad, I'll say, for that great presentation. And you do leave us with a great message, a positive one, that in Uganda, FDI is high. Investors see that the enforcement of contracts is to ease.
Needs your attention.
Apologies for that. And basically, you've also given us a picture of how the institutions have developed within the field of ADR, from having the cadre in place and having this new ICAMEC institution, which is a private independent institution driven by the private sector that saw the need to having a conducive system in place for them to be able to channel their disputes for the purposes of alternative or the appropriate means of resolving their disputes. We move on straight to Rwanda, and we've got Dr. Fidele Masengo. He will be addressing the participants on ADR in the time of COVID-19, implementation of current legal and policy frameworks in Rwanda. Please, Dr. Masengo, the floor is yours.
Thanks, Madeline, for allowing me to also share my presentation about this very interesting subject. Before just starting my presentation, I want to greet everyone, and I want also to wish everyone a new year. We're still in February, it's the beginning, and somebody can say this in midst of COVID, we still need to hear voices telling us that the year will be good, it will be different with the last year. I wish to thank the organizer of this knowledge sharing webinar and all speakers for creating this opportunity for us to explore more ways to advance alternative dispute resolution in Africa, especially during this COVID pandemic season. In as far as the subject of this webinar is concerned, our country has much in our experience that can be the foundation of our talk this evening and beyond. As you know, Rwanda has a very rich experience with the Abunzi, which is community mediation. The Abunzi system has been there for many years and has helped the country to solve dispute through ADR mechanism, which is customized African or Rwandese tradition mediation system. We understand easily how ADR is important in Rwanda because of Abunzi, and before Abunzi, you've probably heard also about Gachacha. So people are really well acquainted with a non-judicial mechanism. The Ministry of Justice and the Kigali International Arbitration Center, as well as the judiciary, have been working to support the expansion of ADR, especially arbitration and mediation as a general system of resolution of dispute in our country. We know litigation is invariably slow, expensive, and time-consuming. Neither can we affirm that litigation really produces the best outcomes. It normally results in a win or lose situation, with the losing party almost always dissatisfied with the outcome, not infrequently unfairly accusing the judge of bias or worse, or even blaming the lawyer for incompetence. With mediation, arbitration, and other ADR, the process is likely to be cheaper and faster, and there is a better chance that it addresses, or those processes address the interests of opposing parties, and ultimately more acceptable to all. We have made some progress, and there is a light at the end of the tunnel. So far as arbitration is concerned, Rwanda acceded and ratified the New York Convention. In 2008, it adopted the law on arbitration and conciliation in commercial matters based on the ancestral model law. In 2010, Rwanda established an independent body tasked with promoting Rwanda as a venue of efficient arbitration services, which is the Kigali International Arbitration Center. Kigali International Arbitration Center has a modern set of arbitration rules inspired by the ancestral rules, but matching with international standards as well. We have provisions on emergency arbitrator, and we've been having cases based on those provisions. The center has close to 200 arbitrators, composed by nearly 100 world-class arbitrators from many countries, international, with repeatable experience in arbitration. The center has case management tools, a practice note, and professional standards. The center has embarked in a robust institutional capacity building effort. Before Kigali International Arbitration Center establishment, no single arbitrator was trained in Rwanda. Today, more than 500 professionals have been trained in arbitration by the Chartered Institute of Arbitrators through the branches of Nigeria and Kenya in Nairobi. So we've trained people from associate level up to the level of fellow of the Chartered Institute of Arbitrators. It's a good news. Maybe many of you don't know about this. We now have a CIArb branch in Rwanda since end last year. It was adopted by the Board of Trustees. We have a Moodle platform that help the center to train arbitrators online. We have, accreditation system requiring a minimum of associate member of the Chartered Institute of Arbitrators to be admitted to the domestic panel. And somebody has, a candidate has to be a fellow of the Chartered Institute of Arbitrators to be admitted on the panel of international arbitrators. One can also mention the increasing, regularity of arbitration conferences, international arbitration conferences in Rwanda. During the last 4 years, CIAC has co-organized 3 big conferences which attracted at least 300 of participants each. The 2017 annual East African International Arbitration Conference, the 2018 SOAS Kigali International Arbitration Conference, and the 2019 annual Africa Arbitration Association International Conference. So this is a testament of, proof that people understand that the country is providing environment that support ADR. On case management, Kigali International Arbitration Case Lot can speak lot on this. Since its establishment in 2012, the center has become a reference with financial autonomy and has administered more than 165 cases. Actually, this number of 165 cases is the number of last year when I left CIAC in December. So I believe we are now close to 170 now. And in recent years, CIAC and its rules have increasingly been chosen by non-Rwandan parties. The geographic diversity of origin of cases, notably people from Burundi, people from China, people from Ethiopia, people from Egypt, people from France, India, Italy, Kenya, Korea, North Korea, South Korea, Pakistan, South Africa, South Korea, North Korea was mentioned, Singapore, Spain, Switzerland, Turkey, Uganda, USA, Zambia. I can't give the full list, but I just want people to understand that we've had many international cases involving parties from around the world. One can mention also the judicial support to arbitration. No single award has been set aside by court up to now. Only decision on arbitrators' procedures have been taken by courts against arbitrators, but it's only in like 2 cases and not a major decision. Rwanda also signed a number of bilateral investment treaties, which all include an arbitration clause, and thus providing that international arbitration has so far been beneficial to Rwanda, not only in the justice sector, but also all other business sectors. CIArb uses online dispute resolution. We have had many cases, being resolved by arbitrators online. We have a modern infrastructure because people can access our high, internet, high-speed internet, and we have cameras and machines that's in our arbitration room. So we are working to have also the case management system that can also facilitate the use of online dispute resolution. We still have to review some of our, provision in our legislation and our rules to make sure that the online arbitration system is well conducted. In as much as mediation is concerned, currently we have provision for a limited role of registrars mediating between parties after filing and submission of pleadings. This procedure has had limited success, but it's really growing. The judiciary has now put in place what we call the court annex mediation since last year, and around 100 professional mediators have been trained. Among those trained mediators, more than 50 are now accredited as mediators by the judiciary. However, a lot more needs to be done to develop a critical mass of certified professional mediators, especially we are building up our professional body to make sure that all mediators are well, known, trained, and ethically followed properly. People who can make a living out of the practice of mediation are governed by professional ethics, have to be well governed by a body that has a legal framework. We don't have that yet, but we have like a task force that is working on it. This is the only way the ordinary people can have confidence in the process and trust them with their problems, assured that the process will be fair and effective. Many awareness campaigns are being conducted by the Ministry of Justice, the judiciary, as well as the Kigali International Arbitration Center to make sure that people know about mediation. Like last year in November, the whole nation, the whole country organized what we call Mediation Week, in which mediators, worked like on volunteer basis, and many cases were like drawn to them, and they helped party to facilitated party to take decisions, so to reach an agreement. So this was really a good thing, a good start, and there are many other planned activities for this year. With COVID-19, the world is now moving from physical to embrace virtual solution in all sectors, including in alternative dispute resolution, especially online mediation, which is really recommended. We are trying also to make sure that this also used in mediation as well as it is used in arbitration. I remember last year, CIArb organized a training with the Cape Town University and University of Cape Town, and subjects on online, hearing, online mediation were also developed. And we believe that those people who have been trained can start using online platform to help parties to reach their agreement through mediation. But we still have to review also our laws and our mediation rules, CIArb mediation rules, to make sure that they reflect the needs of the current context. Practical tips for online mediation have to be also used to train mediators. There is also a need to focus on some aspect of online mediators, such as how to cope with the lack of interpersonal interaction, impact of COVID in mediation processes, benefit of online mediation, as well as the Singapore Convention and its innovation in mediation, and any need for judiciary to move toward also mediation, facilitating also that online mediation. So that's what I can say now. I'm willing to come up when people will be willing to learn more about what we have been doing through questions. I thank you for your attention.
Thank you very much, Dr. Masengo. I think we now can see that there has been a lot of work that has been evidenced by this presentation from Rwanda, a lot of work in grooming a good foundation for arbitration and mediation. And also he touched on the traditional Abunzi and Kachacha non-judicial mechanisms that are adopted in the rich country that we know of, Rwanda. So thank you so much. At this point, we do have questions from the attendees. And I would like to jump through to the questions from the attendees, being that time is not very much on our side. We have a question from Mr. Ahmad Wubu, who asks, could you confirm that the enforcement of awards are effective in East African community? I welcome Ms. Leila Ahmed to try and tackle this question, please.
Thank you for the question. I do confirm that in Kenya, we do recognize and the courts enforce international arbitrations awards. Under Section 2, as I had indicated earlier in my presentation, it recognizes both domestic and international arbitrations insofar as international arbitrations are concerned. Hence, under Section 2 and 36 of the Act, the same are enforceable in Kenya. Section 36 of the Act recognizes that international awards are binding in enforceable as long as it's in line with the New York Convention, which Kenya is a party to. So as long as one can prove and provide to the court the original or duly certified copy of the award and present it to the court, yes, it's enforceable. If someone has objected to the enforcement of the said award, the objector has to prove under the Act again as to why the award should not be enforced. But it takes the same way as domestic awards are enforced.
Thank you for that. Just that we're in Kenya, there's a follow-on with regards to your presentation and whether or not in Kenya, an arbitral award can be appealed. This is a question from Laurent Boni Gaba.
Yes, I did answer her the question in the chat box, and I did discuss on the grounds why we do have the apex court, the Supreme Court of Kenya, that is, has made the two decisions in 2019 that yes, the decisions from the High Court should be or are appealable to the Court of Appeal, although it should be in the clearest of circumstances, and that right should not be abused. So it's also in a limited circumstances.
Thank you, Leila, for that clarification. Mutanzi, I'm coming back to you here in Dar es Salaam, and I would want to know from you, what is your feel? Is the arbitration practice a common practice among young lawyers? You are a member of the Tanganyika Law Society Young Members Group, and so therefore I would like to hear from you your opinion on this.
Thank you, Madeline, for the question. The straight answer would be people know of it, but as I said earlier, it's not commonplace. It's not a go-to mechanism because, again, as I said, it is not something you learn about in school, and after that you find it in practice. And getting to it, because it's already not commonplace to practitioners you have found, it also does not become your go-to means of dispute resolution unless you get an opportunity of exposure through the Chartered Institute of Arbitrators, as I said, or the Tanzania Institute of Arbitrators, or you come across an award in court brought for enforcement, which entices your interest to go learn further. But from the training of lawyers, I would not say it's. I would say it's not a go-to means of dispute resolution to most young lawyers.
Thank you, Mutanzi. And when I'm here with you in Dar, there's a question posted in by an anonymous attendee. And what he says is that what would you suggest is the best way to communicate with arbitration practitioners in Africa to better promote ADR? Should it be through Facebook, LinkedIn, Instagram, Zoom conferences, at a time where large conferences are not possible for the foreseeable future? How to best attract these young lawyers to ADR and inform them about this form of dispute resolution? Can you suggest, please?
Now, if the targeted audience is young lawyers, Facebook and LinkedIn would be Facebook, LinkedIn, and Instagram. Actually, Instagram and Facebook would be my first go-to means of getting the masses. If you can integrate TikTok somewhere in the middle there, the better. But probably it won't be the easiest thing to do. Yes, Zoom does us well. It's not a complicated platform to engage through. But making ADR activities as much as we can mainstream, not an alternative, just as how I call it, the appropriate means. Let's have appropriate dispute resolution mechanism to include litigation, arbitration, mediation, and others. And you choose a mechanism subject to the dispute. The tool should fit the issue or the problem. And then when it becomes mainstream and when it becomes rather a norm, it will be easier to entice young practitioners. But to start with, Instagram, Facebook, those should be a go-to.
Thank you so much, Mutanzi, for that insight. As a young aspiring arbitrator, I understand that you are very active in your social medias. In Uganda, as Manahe, I'm coming back to you. There's a question posed here, and it touches on other types of disputes. It says ADR is more about commercial matters and investment, but what about family matters and labor matters and sports disputes? Can you give us a take in Uganda how these are handled?
Thank you, Madeline. Actually, in Uganda, ADR for us, it's open for most of civil disputes, which would include family disputes. In my presentation, I mentioned that the family division of the High Court has court-annexed mediation as part of the process. Sports disputes, if they were to go before the court, if the matter was filed before, depending on the type of matter, if it's a commercial matter, if it's filed before the commercial court, the dispute would be mediated. Same for labor disputes. The Employment Act is limited on the nature of ADR that can be instituted for employment matters. So the Act clearly provides for the labor tribunal or to handle labor-related disputes, and this is done at that level. So there is no a clear provision for private ADR in terms of that, and the industrial court, which finally would be the trial court for labor matters, does not have mandated court annexed mediation. However, the practice we are seeing now, especially coming from, as a matter of the labor tribunal itself, is that they are promoting the use of voluntary or kind of a private sort of mediation to handle such disputes. So that would be my answer to that. We are quite open for ADR, yes.
Thank you, Asmane.
Madeline, with your kind permission, if I could just jump in.
Okay.
And just to point out one thing, in Kenya, we actually do have the Sports Dispute Tribunal that handles and settles disputes on appeals from the national sports organizations and umbrella bodies. Any decisions by those national organizations go to the tribunal for settlement of the disputes.
Thank you for that. To hear that in Kenya, they actually have a body that is already created for handling sports related disputes. In Tanzania, I can confirm that nothing has been done so far with regards to the sports arena, but we do have a workplace dispute system that is well aligned to the ILO standards, and our Employment and Labor Relations Act does create a standalone commission for mediation and arbitration, the CMA, where all labor matters are channeled as a place of first instance when you're directing your dispute, a labor dispute. Now, just going back to Rwanda so that we can then clock off by having our poll. The poll will be aired just after Dr. Masengo addresses this question from one of our attendees, and I think he's best suited for this question. He goes, "Thank you for the wonderful presentations. My concern is that whereas we want to see our regional ADR centers in East Africa develop with a certain level of trust and credibility, our challenge is that many international clients remain hesitant to accept any arising disputes in contracts to be referred to arbitration and mediation to our regional centers while opting for places like Paris, London, and New York. What should be done to attract the international clients to choose our ADR regional centers and competent to solve any arising dispute?" Dr. Masengo?
Yes, thanks, Madeline. I think this is a very interesting question that needs all of us to think a lot and try to find a solution to that. Actually, before just I give my opinion, I just want to say that this is the mission for the AFA, African Arbitration Association. I'm on the board of that institution, and the African Arbitration Association is hosted in Rwanda, but it's an association that was created to make sure that we advocate for arbitration in Africa, especially when at least an arbitration has an African party. So you understand that it's a mission that we have to keep assuming, and advocacy is, you know, when you start, but you don't know how it ends. And there are many other also competitors, you know, especially those centers that have been there for many years. They are also doing kind of aggressive, marketing to make sure that they don't lose some client who may decide to come in Africa. But to be practical, there are at least 4 things we can do. Number one, we have to make sure that our arbitral institution meet the standards of all other arbitral institutions in the world. So if you meet the standards, quality will speak by itself. If you have arbitrators from London, you have arbitrators from Paris, you have arbitrators from New York, and those arbitrators, some of them are lawyers for, those international companies and firms, so they can easily recommend them our centers if it's really needed. Let me just give you an example. If there is a case between like Kenya and Sudan. There's no need to go in Paris or to go in New York when CIAC is an operational center that has been operating for more than 7 years with a good experience of those cases. But it will depend on Paris to understand that CIAC offers the best alternative to Paris and New York and RCA. So how to do it is through lawyers and well-informed arbitrators who have been coming to our centers. So for us, we don't have that issue now because many arbitrators we are using can themselves refer parties to come to CIAC. And they can even do it after doing submission. So having like an arbitral clause that says, let me say, CIAC in China, then they come to realize that they don't need to go to China because they are all present in the region and they're like changing by submitting to CIAC. So that's what I can say. It's self-marketing, but also raising the standard. Number three, it's also a collaboration between arbitral institutions, because it's easy for me to advise parties to come to Nairobi Center if that party is from Rwanda than somebody else, because I know how the center has been functioning and I can refer to that center. Especially when one party is from Rwanda and the other party is from another country, it's easy for me to refer those parties in the region rather than sending them away in Paris and London. But also you have to know that with online dispute resolution, especially online arbitration, it's not expensive to go now in London than to be in Rwanda, because you cut the cost. So you understand that we have to raise the standard to make sure that people understand that we can offer that alternative they need. Yeah, that's what I can say now. Capacity building, marketing, joint effort of collaboration, and especially references by African lawyers and arbitrators.
Thank you so much, Dr. Fidele. We have a very interactive session. We have 73 participants who are eager to ask questions. There are questions in the Q&A box. Please do try and address them. I'm requesting my panelists to try to address them as we are out of time. But before we drop off, I would like the attendees to please take part in the poll that is about to be launched as of now. Kindly submit your answers. There are questions that have been drafted by the Central Organizing Committee of the Chartered Institute of Arbitrators Young Mediators Group, ADR World Tour, and these will really come into play when a booklet or a guide that will be issued after the tour ends this year. Thank you so much for taking your time to answer the questions of the poll. We've done poll number 1. I also move on to poll number 2, effective force for good. As we proceed to finalize answering the poll, I would like to welcome my panelists to give their closing remarks, 30 seconds each, starting with Leila.
Madeline, you seem to be picking on me. Thank you very much. I'm grateful to be here. For the participants, thank you for joining us. The ADR landscape in Kenya has grown. We intended to grow even bigger and better. There are many opportunities for the young ADR practitioners out there, and we hope that you take advantage of these opportunities. Thank you, Madeline.
Thank you, Leila. Mutanzi?
The future is for the young and the youth. I call upon all the young practitioners to take up arms and march towards this fora of alternative dispute resolution, or as I call it, appropriate dispute resolution. That's all for me. Thank you, Madeline, for the session.
Thank you, Mutanzi. Asmahane?
Thank you, Madeline, and my fellow panelists and our attendees. I think for me, it's just to just re-echo the future for generally the arbitration landscape in Africa. There is also need for a lot of innovation around ADR. We've quickly here hinted on how can we promote ADR, social media, TikTok, in whatever way we can to promote and ensure that there is a simple but clear and effective message in regard to the practice of mediation, first of all for the young lawyers, but also to the consumers of mediation, so that we as we practice and learn and grow our experience and expertise in this area, we still have people who are willing to pay for the service. Thank you.
Thank you so much. And I echo your call for the electronic means of resolving disputes and being able to embrace these technological advancements. Dr. Masengo, a word for us, please.
Yeah, thanks, Madeline. What just I can mention that ADR is seen now as the best option, and its trend is moving with high speed. I encourage young professionals to catch up, learn, and technology is the must if they want to keep, on the track. Thanks a lot.
Thank you all. I thank all the attendees that have been able to join the Africa World Tour, and I also call upon you to register for the other 2 sessions that will be running on the 10th of February and the 12th. The 10th will be Sub-Saharan and North Africa, and the 12th will be SADC region. The Sub-Saharan region will be moderated by Sylvia Bongo, Dr. Sylvia Bongo, and the SADC region will be moderated by Mr. Jackwell Faris. So you're most welcome, and thank you very much. Please do keep safe, and we'll see each other very soon. Thank you.